I want to welcome everybody here for the Joint Assembly and Senate informational hearing. The subject of this hearing is the ballot initiative addressing changes to the juvenile justice system, adult parole for nonviolent offenders, and custody credits for state prison inmates. I would like to thank the witnesses who are here today to help educate us on the issues raised by this initiative. In terms of structure today, for today's hearing, we will start with a presentation on the initiative by the Legislative Analyst's Office. There will be a panel of witnesses who are proponents of the initiative and a panel of witnesses in opposition to the initiative. The proponents will testify first, and legislators will have an opportunity to ask questions. We will repeat the process with the opponents to the initiative. In conclusion, there will be a period for public comment. This hearing is an opportunity for us as legislators to gather information on the initiative, but also a chance to get information out to the people of California who will be voting on this initiative. This initiative addresses two policy areas within public safety that relate to how we, as a state, want to focus our resources within the criminal justice system. The initiative would limit the circumstances in which a juvenile offender could be tried in adult court. The initiative would also provide greater possibilities for state prison inmates to earn credits or parole from state prison. My involvement with the Assembly Public Safety Committee and Budget Sub 5 has highlighted the impact that public safety issues have on Californians. It is critical that we as a state provide effective tools to law enforcement, the courts, and corrections and rehabilitation so that California has a criminal justice system that works for everybody. The Assembly and Senate Public Safety Committees are committed to that goal. We understand how important it is to ensure that the resources of the state of California are used in the most effective manner to advance public safety. I am eager to hear from the proponents and opponents on the merits of this initiative in terms of achieving these objectives. At this time, I would like to turn it over to my esteemed colleague from the State Senate, Senator Lonnie Hancock, for any comments she might like to make.
Simply to concur with Assemblyman Jones Sawyer. As he explained, this is a hearing required by statute. We will take no action. The purpose is simply to inform public knowledge about what is actually in the initiative. I want to thank all the participants today. This is a very important ballot initiative, both for our efforts to build a more effective justice system and also for our efforts to contain the costs and shift costs to some of the front-end things that really build safer communities, like education, etc., mental health programs. So I look forward to a constructive conversation today. I will have to leave somewhere in the middle if the conference briefing convenes, but look forward to hearing as much as possible from the panelists and from the LAO. Thank you.
Thank you. We are joined by State Senator Joel Anderson, Assemblymember Bill Quirk, Senator
Bill Monning,
and Senator Mark Leno today. Did any of you want to make any opening comments? No? Hearing none. Then Mr. Drew Soderberg, Managing Principal Analyst, Criminal Justice Legislative Analyst's Office. You may begin.
Good morning. I believe the sergeants have passed out a handout to you that provides an overview of our remarks. If you return to the first page of our handout, you'll see an overview of the LAO's role in the initiative process. This will probably look familiar from our other hearings. We have two roles. First, our role starts before the signature gathering phase of the process. At that point, we're required to do a joint impartial fiscal analysis with the Department of Finance. The summary of the analysis appears on the petitions that are circulated for signatures. Next, after an analysis qualifies for the ballot, state law requires that we complete a description of the analysis and provide, once again, a fiscal estimate. That's included in the voter guide that's mailed to registered voters throughout the state. We're in the process of completing that part of our analysis, so at this point, my comments today will largely be based on the analysis we completed earlier in the process. If you turn to page 2 of the handout, you'll see some background on the measure. So this measure really has 3 different parts: an aspect related to parole consideration, sentencing credits, and changes to juvenile justice. So I'll start with some background on parole consideration. Inmates can broadly be thought of, for the most part, as indeterminately sentenced or determinately sentenced. Indeterminately sentenced inmates are sentenced to a sentence range, such as 25 years to life, and must appear in front of the Board of Parole Hearings for a parole consideration hearing in order to be released. However, determinately sentenced inmates, which constitutes the vast majority of inmates in the state system, do not have to appear in front of the Board of Parole Hearings or have a parole consideration hearing to be released. However, there are some determinately sentenced inmates who do qualify for parole consideration prior to serving their entire term. So one example of that is if an offender has committed their crime before their 23rd birthday, they are eligible for a parole consideration hearing in the 15th year of their sentence. Now I'll turn to sentencing credits. Under existing law, the California Department of Corrections and Rehabilitation can award credits to prison inmates that reduce the time they must serve on their sentence. These credits are provided for good behavior, participating in work and training or education programs. Inmates can reduce their sentences by as much as 1/2 through the provision of these credits. However, there are restrictions on the amount of credits that some inmates can earn. For example, inmates who have been convicted of using a firearm while committing certain felonies can only reduce their sentence by 15% through credits. If you turn to page 3 of the handout, you'll see some background on juvenile justice. To begin with, individuals accused of committing crimes when they are under 18 are generally tried in juvenile court, which differs from adult court. For example, rather than sentencing youth to a set term of incarceration, juvenile court judges determine the appropriate placement and treatment for them based on factors like the youth's offense and criminal record. Counties are generally responsible for the youth placed by juvenile courts. These youth are typically allowed to remain in their homes. However, they can also be placed outside of their homes, such as when they're placed in juvenile camps or ranches. Judges can place youth that commit certain major crimes, such as murder, robbery, and certain sex offenses. These are the so-called 707B offenses, in a facility operated by the State Division of Juvenile Justice. Counties must pay a portion of the cost of housing these youth, and youth released from DJJ are supervised by county probation officers. However, youth can also be tried in adult court. Specifically, individuals accused of committing crimes when they are 14 or older can end up in adult criminal court in one of the 3 following ways. First, they can end up there through a fitness hearing process. A prosecutor can request a fitness hearing where a juvenile court judge decides if a youth should go to adult court. If the crime occurred when the youth was age 14 or 15, it must be one of certain major crimes, again, murder, robbery, or certain sex offenses, those 707B offenses. Now, if the youth was age 16 or 17, the prosecutor can seek this hearing for any crime, but typically will only do so for more serious crimes or for youth with a significant criminal history. If you turn to page 4, the background will continue. The second way youth can end up in the adult system is through a direct file. If a youth has a significant criminal history and or is accused of certain crimes, such as murder, a prosecutor can direct file charges in adult court with no fitness hearing. There are generally more circumstances under which a youth who is accused of committing a crime when 16 or 17 can be subject to a direct file than is the case for youth who were 14 or 15 at the time the crime was committed. In addition, youth can end up in adult court through a mandatory filing. If a youth is accused of committing murder or certain sex offenses with aggravating special circumstances, such as also being accused of torturing the victim, he or she must be tried in adult court. Youths convicted in adult court when they are under age 18 are typically initially held in DJJ. When they turn 18, they are generally transferred to prison. However, if a youth can complete their entire sentence before turning 21, the youth will spend their entire term in DJJ. The state pays the cost of housing youth in DJJ if they've been sent by adult court. After release, whether it's from prison or DJJ, these youth are supervised in the community by state parole agents in general. So if you turn to page 5 of the handout, that's where we begin our description of the measure. To begin with, the measure amends the state constitution to specify that any prison inmate convicted of a nonviolent felony offense shall be eligible for parole consideration after completing the term for his or her primary offense. The measure authorizes CDCR to adopt regulations to implement this change. Under the measure, the primary offense is the longest term imposed, excluding any additional terms added to an offender's sentence, which include any sentencing enhancements, such as the additional time an offender must serve for having previously been convicted of a felony. As a result, nonviolent offenders could be released after serving the term for their primary offense. The measure also amends the state constitution to specify that CDCR shall have the authority to award credits to inmates for good behavior and rehabilitative or educational achievements. The measure again authorizes CDCR to adopt regulations to implement these provisions. As a result, CDCR could authorize credits beyond the limits currently specified in statute. Finally, if you turn to page 6, you'll see a discussion of the changes to juvenile law the measure makes. The measure modifies statute to require that all youths have a hearing in juvenile court before they can be transferred to adult court. The measure specifies that hearings to transfer youth to adult court could only be sought for youths accused of committing certain major crimes, again, the murder, robbery, or certain sex offense type crimes, when they're age 14 or 15, and for youth accused of committing a felony when they were 16 or older. As a result, prosecutors could not charge youth directly in adult court, and no youth would have their cases heard in adult court on a mandatory basis. Accordingly, there could be fewer youth tried in adult court, and these youth would generally be subject to shorter terms. So if you turn to page 7 of the handout, you'll see a discussion of the fiscal effects. I'll discuss the fiscal effects of each aspect of the measure separately, but in general, you'll see that the measure would likely create net state savings and create county costs. So I'll begin with the parole consideration. If nonviolent offenders serve shorter terms in prison, it would reduce state costs as the size of the prison population would decline. These savings would be partially offset by a couple factors. First, BPH would experience costs associated with considering inmates for parole. Second, if serious offenders are released early, the state could experience increased parole costs for roughly a decade to supervise these offenders. In total, net state savings would likely be in the tens of millions of dollars annually on an ongoing basis. In the short term, however, the net savings would be higher as there's a large number of inmates currently in prison eligible for parole that would be eligible for parole consideration hearings. Now turning to the counties, if non-serious, non-violent offenders who are supervised by county probation officers following release from prison are released early, it would temporarily increase county costs to supervise them. We estimate these costs could range between the millions and tens of millions of dollars annually for a few years. Now I'll turn to the credit provisions of the measure. If CDCR granted additional credits, the size of the prison population would decline, resulting in a reduction in state correctional costs. If the additional credits expedited the release of serious or violent offenders, these prison savings would partially be offset by increased parole costs for a period of years. However, the fiscal effect of this portion of the measure would depend heavily on the number of additional credits authorized by CDCR. If CDCR only authorized a minor increase in credits, the fiscal effects on the state would be relatively minor. However, if CDCR issued enough credits to allow inmates, the average length of time inmates serve to be reduced by, say, a few months, it could have a substantial effect, resulting in net state savings in the low hundreds of millions of dollars annually. These provision would also create some county costs. If the additional credits expedited the prison release of non-serious, non-violent offenders, as we discussed before, it would temporarily increase county costs to supervise them in the community. Again, this would have a wide range depending on how CDCR implemented the measure. It could be minor, or it could create costs in the tens of millions of dollars for a period of years. If you turn to the last page of the handout, we'll discuss the effects of the changes to juvenile justice. If fewer youth are tried and convicted in adult court, the measure would reduce state costs, as these youth would no longer spend any time in prison or be supervised by state parole agents. In addition, because juvenile court proceedings are generally shorter than adult court proceedings, it would reduce state court costs. Now, these savings would be partially offset, as these youth would generally spend more time in DJJ. However, counties would be required to pay a portion of those increased costs. In total, we estimate that the annual net state savings could be around a few $1 million annually. Now turning to the counties, if fewer youth are tried and convicted as adults, it would increase county costs, as the counties would pay a portion of the cost, as I mentioned earlier, of housing these youth in DJJ. And county probation departments would be responsible for supervising them following their release. Again, because the length of the court proceedings would likely be shorter, those county departments that are involved in them, like the DAs and the PDs, would also experience some savings. In total, we estimate that the net cost counties would experience due to the measure could be around a few $1 million annually. I'll now be happy to take any questions that you might have.
Are there any questions from the members? Mr. Court.
I'll just make a comment. If this does pass, I think it's going to be important for the state to reimburse the counties for these costs, assuming that the state does get savings.
Ms. Hancock, I know you have to leave soon. Do you have any?
No, to me, this looks like, and I'm interested to what the panelists think, a push for prevention, which would lower county costs and state costs if we keep our kids in school, keep them engaged, intervene early when we see a problem. And, you know, when we talk about savings, I agree. What do we really mean? But it's kind of where we invest in our people. But thank you for the presentation.
Thank you. Mr. Leno.
Thank you, Mr. Chair. From what I've heard, Mr. Soderberg, with regard to the fiscal effects, it's possible there will be some cost shifting from state to county, from county to state, all at this point yet to be determined, because so much of the authority will be in the hands of CDCR, and we have no idea, should the measure pass, exactly how they would make use of that authority. So I think there's a lot of uncertainty about what the costs will be and who's going to be paying them. I do have a very important question, though, because we've been around this bend on Prop 47.
Yes.
On your page 7, with regard to net savings, if nonviolent offenders serve shorter terms in prison, it would reduce state costs as the size of the prison population would decline. What figure? Is it noted in the initiative, or are we going to have to debate subsequent to its potential passage? How much savings per inmate are we talking about? Because finance seems to have a very different number from what you have.
That's correct. So we estimate that the state saves about $29,000 to inmate, to the extent that it results in the state not needing to put the inmate in a contract bed. In the analysis of Prop 47 that the Department of Finance did, they really focused on inmates that they felt were displaced from the state's 34 prisons, and the savings there is quite a bit lower, about $11,000. However, our approach to these measures has generally been to assume that the impact is on contract beds, because those beds have been necessary to comply with the court order. And until we are able to eliminate those beds, it's difficult for the state to make large changes in the size of its 34 prison population.
So if I remember correctly, Prop 47 let the Department of Finance determine the amount of the savings. How is this measure worded relative to that point?
This measure doesn't have provisions requiring a determination of savings. Likely what would end up happening is that through the normal budget process, CDCR's budget would be adjusted. And one thing I would want to note about Prop 47 is irrespective of the way the department calculated the savings, the budget process does result in automatic adjustments that are independent of the savings that was calculated by Department of Finance. So in this case, my assumption would be that those standard budget procedures would come into play and CDCR's budget would be adjusted, even if there was disagreements about how to account for how much of the adjustment was related to this or that measure.
But what is the determination of which rate would be used?
Typically,
You say they would automatically be calculated, but using what rate?
well, essentially what the department would do is they would take a look at the size of their in-prison population and their size of their contract population and account for adjustments that occurred over the time period.
Okay. And just so I have the terminology correct, there are contract beds, and you said the figure for that is
About $29,000 per year.
And then the
yeah.
other,
That's closer to about 11,000. So those are the inmates that are housed in the states. I said 34 earlier, but really 35 prisons counting.
right. But what's the term for those beds considered 11,000?
They don't necessarily have a set term. We just call them the sort of CDCR operated beds.
Okay. Thank you.
And did you give that number? I'm sorry.
Yes, that's about roughly $11,000 per year.
Per savings or the cost of incarcerating a person?
So if either way, if you add an inmate to the 34 or 35 prisons, it's about $11,000 per year, and then if you remove them, it's about $11,000 per year.
And that's because we're discussing the marginal cost.
Exactly, correct.
And what is the basic cost of maintaining a prison bed?
The average cost is quite a bit higher. So the average cost, if I recall correctly, is around $60,000.
Not right. That's what okay. And what is the average cost of a contract bed?
The average cost of a contract bed and the marginal cost are really basically the same because the way the contracts are operated is they go up and down.
Yeah, right. So that would be 29,000. And when you say contract beds, do you mean our in-state private prisons, or do you mean the out-of-state placements?
Both. So the 29,000 is a blended rate that accounts for both the in-state and out-of-state contract.
Okay, and how many of those are there, the out-of-state and private?
So I believe it's roughly half and half, and I believe in total the most recent numbers I can recall are around 9,000 beds.
Around 9,000, that's what I thought. That has implications for savings, too.
Correct.
Because we would theoretically want to shut down those contract and out-of-state beds before closing any California prisons. And I would note that our prisons have about 4,000 inmates in each prison. So we're talking 2 full-size prisons, private and out-of-state. So we have a way to go, and I think we should realize these measures are simply setting us on a path. Thank you.
And I just wanted you to think about what you said, because if we had your counterpart from the Department of Finance sitting next to you, would he or she say the exact same thing that you just said, which goes to Mr. Leno's question, because we have to be we're very concerned, because I always say it's not about legislation, it's about implementation. And if we're back here and we read something in this ballot initiative that says the finance department, because some people have determined that the finance department has the sole authority to make the determination by August 1st, and that we don't have any input, and now you're saying we do. And so I don't want to get back to this, if it should pass, that we're now back again debating what that number is, because your numbers are much significantly different than Department of Finance. So would you say your counterpart would be saying the same thing?
I would hesitate to speculate on what Department of Finance would say, but I think that they would agree with our overall account of the way the budget process works. And it's important to note that unlike Prop 47, this measure doesn't require a calculation of savings for a subsequent deposit. And so Prop 47 really has a two-step process. One, there's the adjustment of the budget for the Department of Corrections, and then there's an accounting of how much savings could be attributed to Prop 47, and that amount is deposited. So under both scenarios, both will have the automatic adjustment of the budget for CDCR. Just this measure won't have the calculation of the savings deposited into a special fund.
Okay, Mr. Monning. So.
Thank you, Mr. Chair. On the youth sentencing component that you described, it wasn't clear to me. It sounded as though if a county pursues prosecution as a youth, that the county bears the cost of the incarceration, but if they're tried as an adult, the state shoulders the cost. Is that accurate?
That's correct, yeah.
So would it be fair to say that a county in charging, there would be an economic incentive to charge youth offenders as adults, that there may be an economic benefit to pursuing that option?
Yeah, there would be. I mean, obviously, when a prosecutor is deciding whether to do that, there's lots of things that they consider, but an economic incentive exists there. I think it's unclear whether, I think probably most DAs would say that doesn't enter into the calculation, and we don't have evidence either way of whether that's the case, but you're absolutely right about the incentive.
Is it fair to say if this proposition were to pass, it would remove that aspect, or would there still be a component of that?
There would still be that component there. Essentially what the measure does, simply speaking, is require that a judge evaluate whether a youth be tried in adult court, whereas now there's a couple different ways that evaluation can, a prosecutor can avoid that evaluation, whether it's due to a mandatory file or a direct file.
So is it fair to say that this involves judicial discretion more than the status quo?
Yes, it does expand judicial discretion.
Thank you. And then this perhaps goes beyond the scope of your assessment and maybe better shared with proponents and opponents. But on the credits proposal, do you have any way to quantify if there's, beyond the economics of it, in terms of guard safety, is there any data that shows where you have more incentives for inmates to reduce the length of their sentence, that there's a commensurate reduction in inmate on guard violence or inmate on inmate violence?
There would be an incentive for inmates to have better behavior, and there would be an incentive for inmates to participate in rehabilitation programs, and I believe there is research out there showing that such participation can improve the behavior of inmates in prison. Though offhand, I'm not aware of specific research on that, but the incentive structure would be there to create that.
And then it's not clear to me from whether the measure itself prescribes what those credits would be, or it just empowers prison administrators. And is it prison by prison? Could you have one set of credits recognized by a warden at one prison versus another, or would CDCR do that system-wide?
So the measure vests the authority in the Secretary of CDCR, and they would adopt regulations. However, that the measure is silent on exactly what those regulations would look like. So while if CDCR maintained its current practice, it probably wouldn't vary prison to prison, but the measure is silent on it. And so theoretically, CDCR could adopt regulations to that effect. But it's pretty open-ended.
But that helps me. It empowers the Secretary of CDCR to adjust or expand credits.
Yeah, and it would require them to go through the regulation process. So.
And would we have oversight in that?
There is a bit of a legal question there as to whether or not the constitutional power of the secretary could sort of be hemmed in by statutes passed by the legislature. I think that is probably something that would be worked out by the courts.
Thank you. Thank you, Mr. Chair.
Thank you. Are there any more questions? I just had, and I may have missed it, I just have one more about the cost for supervising an inmate on parole or post-release community supervision for a year. Did you give those costs, or do you have any idea what those would be?
Sure. I didn't give them yet. So the cost for parole, we have very good data on that. It's about $6,500 on average per parolee per year. The cost for people supervised under post-release community supervision is a lot less clear and likely varies substantially by county. When the state set up the 2011 realignment, it provided a sufficient amount of funding in general to so that each county could theoretically spend about $6,500 per year on PRCS offenders. However, individual county decisions and the allocation formula that was adopted later could change that county to county. And historically, counties have spent quite a bit less on their probationers, about $1,500 per year. So we would expect that the spending on PRCS offenders probably ranges between $6,500 to $1,500. Though it's going to vary substantially by county and based on county decisions.
Okay, thank you. And seeing no more questions from the committee, I want to thank you, Mr. Staudenberg, for your testimony. What?